preferable for it to be in the presence of the defendant? Of course, but you've got a defendant who allegedly does not want to come to court. Now, eventually they can extract him and bring him in, whether he likes it or not. But the judge was saying the answers are going to be in writing, and hence he's really not going to miss much. And he may be right about that. I mean, all he's going to do is ask questions and have them provide answers in writing, which attorneys can later share with their clients. But the judge was very clear about one thing, that when the time comes and the trial, in fact, starts, if he does not want to come, he's going to be extracted. That's at least what I think I heard. Could there be issues on appeal later? I mean, I'm sure it could be raised. But again, I don't think, because all the answers are being written down and are going to be available to him, I don't think there's any real significant problem with what the judge just said.
All right, I also want to bring back in our Honorable Tiffany Porter, a municipal court judge, criminal defense attorney. Tiffany, what do you think as a judge? You know, it's a hard decision. It's a lot of balancing. And again, we're looking at a 5-month trial that's been planned for a long time. It started before COVID. You've got investigators. You've got witnesses, all of whom had to be lined up for this 5-month trial. And let's not forget, this was a murder that happened some time ago based on the disappearance, according to the state's theory of the case, from the 1980s. So all of this, at what point do we think the justice system might be able to actually have a trial so a jury can make a decision?
Well, we really don't know, because the law really insulates, defendants, and really we're supposed to make sure that their rights are protected. And if he refuses to come out today, of course, having something in writing will help. But if I were his attorney, I would still keep pushing and doing motions and whatever it is necessary to keep this being held up. Of course, as an attorney, you should not, you want to move forward. But what I'm saying is, if for any delays with this trial, especially the nature, the evidence, and how long it's been, the longer, the better for him, of course. But I think when you leave things open to where defense attorneys can come in and try to argue that their client wasn't treated fairly, or that there's some other information that the jurors should not know, those are things that you fight for. And even if you don't think that you can win them, you still go down that path to keep things at a halt.
And again, the judge did say, I don't find it prejudicial to the defendant to have the jury write down answers to 3 questions. So in his mind, certainly he's making clear he has to think about prejudice to the defendant. In the last 30 seconds that we have, Laura, I know that I'm going to be signing you off. I really appreciate you joining us today. Any final thoughts in the last few seconds about this case?
It would be interesting to watch. I mean, I would expect that this trial would actually go forward, because I don't think Mr. Durst's health issues are just going to disappear, and this is going to be a continuing issue. What the judge can probably do is monitor his health, and as long as he can be physically in court, I think this is going to go forward.